rise. The Court of Appeals, Division 1 is now in session.
Thank you. You may be seated. So we are here in our case number 1CACV170088, BUSSBERG versus Walker. Counsel, as you know, each side is allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to reserve for use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself. The clock on the podium will reflect the total amount you have remaining, including what you might have decided to reserve. We've read the briefs, and we've studied the record, including the hearing transcript. And we've also discussed the case among us in a conference. So with that, you can proceed.
Thank you very much, Judge Johnson. My name is Mark Sipple. I am the lawyer representing the appellant and the proponent of the will, Gail BUSSBERG, below, and would like to reserve at least 5 minutes for rebuttal, and will do my best to keep track of that time. And what we are asking this court to do is to, number one, honor what is clearly the testatrix's intent, that all sides have agreed that's what the document, that was her intent, that we follow the plain language of the statutes that apply to what it requires for two persons to, that the will is signed by two persons, that we ask that the statute that defines what a notary public is, 41311, the definition actually says a notary public has to be a person, and that was a question below, and follow the plain meaning of the words witness or to be a witness, and in so doing implement the doctrine of judicial restraint and distinguish the BUSSBERG case and its fact findings and the record that it held from the Mutter case as being very, very different. Now, with that foundation, we start that the record, the trial record, is everything. If it's not in the trial record, it should not be part of a decision. And West versus Baker and progeny made that very clear. The problem in the Mutter trial record was that the only issue raised to that trial judge was whether the will was holographic or not. That was the issue. There was no testimony that there were witnesses that signed. There was questions. There was a declaration of counsel. But when you read the record, which is only 7 or 8 pages, that was not at all an issue. When it went to the Mutter court, again, the only issue was whether the will qualified as a holographic will. And our position is any other comments that the Mutter Court of Appeals or Supreme Court made were dictum. There's no necessary requirement that you first disqualify a will under 142502. You don't have to disqualify it as not being witnessed or two persons signing along with. And that the court went that far is why we're here. We believe that it should be distinguished and that it should be ignored because it is dictum. There was no necessary finding. The Supreme Court, in its decision, and Mutter, specifically said the issue is whether this is a holographic will.
Well, it's kind of odd, isn't it, that the Court of Appeals decision, this court's decision in that case, said there was no evidence in the record and apparently none was offered that the witnesses who signed the document witnessed the signature. So, and I mean, it seems to me the best we can say if we decide to go your way is the Supreme Court did not address the issue. It passed over it. It assumed the answer without deciding the issue that your case seems to have teed up. On that point, what do you think the word witness means in 2502?
Witness is one of those multi-purpose words. It can be a noun. Someone can be a witness. It can be a verb, I witnessed, or I was, and it can be used in a couple of English grammatical things that I will confess I've forgotten over the years. But the process of, it would be very weird to hear from a trial, I am a witness and I witnessed and here's what I witnessed. And then they run through the litany of facts. As opposed to the lawyers or the cross-examiners just asking, what did you see? What did you hear? What did you understand? What was told to you? What can you tell us? So the word to witness isn't a magic word. It isn't something that is specially required, and unfortunately a lot of the older courts and older court decisions in the East Coast found a lot of emphasis that you had to use certain magic language or certain magic words. Our statute is a lot clearer and less stringent than those statutes. I also found it interesting with the word.
Your definition of witness, it would then be simply someone who saw the will being signed?
There's a little more to that, and I think when we went through and bullet pointed that in our reply brief, to be a witness, you have to have seen something, heard something, and be able to articulate what you have seen, what you have heard, and there's an understanding of what's going on. As I said earlier, no party has questioned or challenged that this was the testator's intent. In fact, Mr. Walker specifically signed, I agree. So he had to have known what was in the paperwork, and in fact, when the chain of history was taken out or laid out, he did understand what was in the will. He took it back and forth to Tamara Adamovich, who was the one who typed it out and who was the notary.
Do you agree that on its face the document would not be enough without some testimony? The statement that I agree, is that enough?
I am one who believes that unless it is self-proved, and this is not, the notary cannot notarize herself or she has to be in one position or other. Unless the will is self-proved, it has to go through a formal proceeding, which is an actual hearing with testimony, and testimony of someone identifying what they saw when they saw that the two persons were there, that they saw what was going on. They understood. The testatrix has to know who they are, who the natural objects of their bounty are, and what documents they're actually signing and what's going on. So I think there's more to being a witness and proving it at the hearing, and that is what we endeavored to do, especially when we called Ms. Adamovich back with the graciousness of opposing counsel and the willingness of the judge to reopen the record to make it as complete as possible. It seemed to me that the appellee focused on that the notary could not be a person who was also a witness. And interestingly, the word notary or notarized, notarization, does not appear in either Mutter decision at all. In fact, it doesn't appear in the probate code at all, except in 145501, which is where in a power of attorney it has to have a witness, and that witness has to be notarized. So this concept of exalting the notary public to exclude her from a witness, we think is simply incorrect as a matter of law. In the same way, Mr. Walker was there. He saw, he knew, he testified, and so his statement, I agree, without anything more, yeah, I am troubled by that, Your Honor. However, I think the record that we established overcame that completely.
What about the comment to the UPC about how someone needs to sign as a witness, sign as a witness?
Again, that comment is also in context with the intention to find that, of testator or testatrix's intentions be followed and adopted as much as possible. I find that comment to be, again, looking for magic language, and the word witness, to be a witness or to witness something, has a lot of fill-ins that we as trial lawyers attempt to do in every case when we bring anyone to the court, to the stand to testify under the rules of evidence. We have to show that they have personal knowledge. We have to show that they witnessed, that they saw, that they experienced with their five senses. It wasn't a dream in the middle of the night. There's certain concrete things that have to be shown, and that's what the concept of being a witness is.
You know, this isn't raised so much in this case because of the testimony at the trial, but if you think of witness as a verb, meaning I observed someone, I observed an act, can that may mean that would encompass I saw the act. Could it also encompass other means of perceiving the act?
Great question. That almost becomes philosophical. I wouldn't want to just limit it to I observed. I believe that in the process of having a will, last will and testament, and having two persons, they are attesting to certain facts that the person is over the age of 18, that they're not under undue influence or any, that they're competent, and that the circumstances, they know what they're signing. So I think there's more to it than just observed. I know our statute was later amended to allow a witness to place their signature on afterwards as a witness.
If the testator has acknowledged.
Correct,
Yeah.
but there had to be additional proof of that.
Yeah. Well,
But so when we say sign as a witness, that necessarily requires that the witness have been told this, these factors that you're discussing, that the person is of sound mind or whatever, that knows the object of their bounty. I'm just a little bit, I'm not sure in what other capacity you would be signing. If you sign in your capacity as a witness, what other capacity would there be that language seems, I'm not sure that it adds very much, but I'm trying to figure out, would there be some other context in which someone could sign in some other capacity and not as a witness? Or are you saying that it would be without having gone through the factors to understand, to know that the person knew what they were doing?
In Arizona, I think the answer is no. The signature, I saw it, I accepted it, I agree with it, is sufficient. Other states seem to labor over that distinction. Other states, they talked about, when a notary steps out of being a witness, or where the testatrix themselves say, oh, I didn't want them to witness the will, I just wanted them to notarize, which seems very contrary to our Arizona concept that what we're doing is we're validating an act of a testator or testatrix by certain formalities and having two persons sign, having seen the act, having observed, having watched that. To have the testatrix say, no, I don't want them to be the witness, seems strange to me, but those are other states which we don't think are binding authority at all to this court.
And we wouldn't, I'm sorry to just be sort of rambling, but if we just had two signatures from other people who don't say anything about, I've known this person, I know this is exactly what she wants to do, but they're just two witnesses who've signed something, and then the notary comes in and notarizes, or even without a notary, there's just two people who've signed it. Even though it's not a self-executing will, that's enough. We don't have a requirement that the witness say something in the on the face of the document.
I would divide that into two parts, Your Honor. One is, what does the document say, and is it a sufficient document to bring to a formal hearing for the court to hear that?
Let's say it just said, witnessed this day by John Smith.
I would think that'd be sufficient if the court testimony showed and established the validity of the documents and the people's and the signatures.
Well, there's no, I mean, what's the authority for, I don't know that you're arguing this, but in fact, I think you're probably not, but what would be what's the best thing that can be said for the proposition that the two witnesses need to be also qualified to testify to the mental state, undue influence, all those factors? I mean, I don't read that in the statute, do you?
I don't. However, I will say, I think we really tried to cover that as thoroughly as possible in our record. We went back over that. So I think we met that burden, although I don't think it is a burden that has to be met.
I don't read the other side as contesting your mental state or undue influence. I don't think that was.
And that was what I was inartfully trying to get at, that it may, if there is an argument to that effect, that comes up in the form of an undue influence claim, not a claim relating to how the document was signed. I mean, if that can be raised in a different.
I would agree with that.
point.
I agree with that. And my 5 minutes for rebuttal is.
Saved.
Thank you.
Good morning.
Ms. Aguirre.
May it please the court? Alicia Aguirre, on behalf of the respondent, Timothy Everson. It is our position that the murder case is a precedent in this particular case. And the reason we believe that is because the Supreme Court specifically addressed the issue of witnesses to a last will and testament. The word notary is not in the murder decision. It's not mentioned. However, the court did discuss what constitutes witnesses for the purposes of a last will and testament.
But do you agree the court could have reached the same holding that it reached in, I don't know if it's Mutter. It could have just reached its holding and said, because we decided this way, we need not address the issue of, to the extent someone had raised the notary issue. Would you agree that the issue was not necessary to the way the Arizona Supreme Court resolved the case?
Yes, I do agree. I agree that.
But so then, if that's the case, why isn't it just dicta that?
Because the court went through an analysis of what constituted a witness, and witness is.
Where did it do that?
Well, it went through the statute.
Well, it went through the
And
photographic statute.
Under the section 4 was a document, a valid will. Under ARS 142502, the court is discussing that the legislature has the power to determine what's a valid will, and our legislator has stated that it requires 2 witnesses. The statute is silent on a notary being a witness. However, referencing the Uniform Probate Code, our legislature did not enact the notary as a witness language. It could have, but it didn't. In fact, we have other statutes in this state pertaining to powers of attorney, health care, powers of attorney, mental health care, where a notary standing alone can serve as a witness.
What purpose in this particular will, in your view, did the notary serve?
The notary served the purpose of acknowledging a signature. And it's clear from the record that the notary added additional language to this document on her own volition.
That doesn't undermine the fact that she witnessed Bradley sign, though.
Correct. She did witness Miss Bradley sign. A notary witnesses a document being signed regardless of what it is.
But my question is, what, in your view, what earthly good would it do in this in that room? What earthly good did the notary serve?
In my view, the notary served the purpose of setting a record that someone signed a document. No different than someone signing the title to a vehicle. They witnessed a signature. The notary, however, did not indicate, I am signing as a witness to Ms. Bradley's last will and testament. It's also our position that even if the murder case is not considered to be precedent, in this case, even Mr. Walker didn't sign as a witness to a last will and testament. He signed that he agreed to carry out whatever directives she set forth.
What in your view does the word witnessed mean in section 2502A3? What does that mean?
It means that the person was there and they were aware of the contents of the document. They had a conversation with the testator, or the testator told them, I'm signing my last will and testament, or someone informed the individuals that they were signing a last will. The testator was signing a last will and testament.
So the person, okay, I'm going to ask you in a minute what
Yes.
authority you cite for that proposition.
Okay.
But so what are the elements in your view that are required of, or that are implicated by the verb witnessed?
That the person was present,
Present?
and that the testator acknowledged that they were signing a will.
Okay. And what else?
Those are the two elements of the statute,
Okay. And, well,
of that particular subsection.
well, that's what I'm talking about. So, signed by at least two people, each of whom signed within a reasonable time after that person witnessed either the signing of the will, and that's the component that we're talking about here.
Yes.
So in that section, what does it mean to have witnessed the signing of a will?
That means that the person is aware that the testator is signing a will.
Okay.
And
Okay.
are you suggesting that it's not clear from the record that Mr. Walker knew that the decedent, or that Ms. Bradley had signed a will and wasn't present when Ms. Bradley signed the will?
No, I'm not suggesting that at all. He was present when she signed the document.
I'm sorry.
No, are you saying then that he doesn't satisfy the requirements of the statute as a witness? Mr. Bradley? I'm sorry, Mr. Walker.
Mr. Walker, he satisfies one of the witness requirements, but we don't have the two witnesses required. He also,
Which is the one requirement that he satified?
well, that he witnessed the signature of a document.
So he saw her sign before he signed.
Yes.
Okay.
Are
Now,
you saying he doesn't understand that it's a will?
he signed that he agreed to carry out her directives. He didn't sign that he acknowledged that she was signing a will.
What else would that mean, though, that if he agrees to the directives, and it says, these are my directives or wishes prior to my death?
Well, again, we have a situation where the document, number one, is not clear that it was a last will and testament. And because it wasn't holographic, in that case, it's difficult to determine whether or not it was a last will and testament.
Is that an issue?
No, it's not.
I didn't see that. Okay. So that's not really contested on appeal, is it?
No. Again,
You agree then, if that's not an issue, you agree that Mr. Walker at least satisfies the language of the statute as in terms of being a witness, having witnessed to the will?
as one witness to the will.
So your argument
Yes.
is just simply on the
On the
that
notary.
The notary
Yes.
does not. Okay.
The notary does not satisfy the element of a witness to the will.
And you acknowledge that she witnessed that is the fact that she's done something in addition to, does that alter the fact that she witnessed Ms. Bradley sign the document? And is there a question that the notary didn't understand that it was these were Ms. Bradley's wishes to be carried out on her death?
The record reflects that the notary did question Ms. Bradley, whether she knew what she was doing. So there would be some indication that she asked. There was no testimony as to whether she asked if it was a last will and testament. So as far as knowing whether it was a will, I can't answer that. I can.
But that's the same issue regarding
the record-
Mr. Walker, right?
Well, the record shows, though, that the notary included additional language on the document. You know, she didn't sign in the space where the witness signed. She signed elsewhere on the document, and she attested that she was signing in her capacity as a notary. And again, I go back to the fact that in Arizona, our legislature did not adopt the Uniform Probate Code language that allows a notary to serve as a witness.
Well, the
For-
Uniform Probate Code allows says you can have either two witnesses or you can have just one notary.
Correct.
Either one is an equally good way. So I'm not sure it's correct to say that the legislature doesn't
But-
allow a notary to sign as a witness.
In this particular instance, for witnesses to a will, our statute does not give us the option to have a notary be the only signature, be the only witness on a will.
Yeah. So I'm just wondering, so what tells us that the legislature also intended by that a notary could not serve as one of the witnesses when the acknowledgement that the notary signed here says exactly what the statute would require to be a witness. The testator personally appeared and acknowledged signing the deed, or the acknowledged that she had signed of her free act and deed, and that's the second part of the witness statute, isn't it?
Yes.
Signed after the testator's acknowledgement of the signature. I mean, so, but for the notary seal, would that have done it? If she'd omitted the notary seal, would that have qualified her as a witness?
It's possible.
I
don't know.
Tell us how we know.
How do we
you
know?
when a notary is acting as a witness rather than a notary?
A notary is acting as a notary when they use their notary seal, when they provide a service under that capacity as a notary. If a person is just signing a document, they're not going to add the notary seal or their official title as a notary.
But doesn't that just translate to I served as a witness and I did something in addition? There doesn't seem to be any dispute that she satisfies the requirements as a witness, and she just happens to also satisfy some additional requirements that she can provide an additional certification on the document. But being overqualified doesn't seem, it seems odd that would disqualify you from doing something, from something that you're obviously qualified to do, and it doesn't remove your qualifications to be a witness, right? At least, is there some authority to suggest that having additional qualifications eliminates or makes you unqualified to serve as a witness?
I cannot answer that at this moment. But I believe that In this case, the issues before the court are, what constitutes valid witnesses, and the statute 142502 doesn't state anything about having a notary as a valid witness. So, nothing further.
Thank you.
Thank you.
First, we definitely agree that overqualification does not become a disqualification. And put this in the context of public policy. Small town, Kingman, Arizona, Mojave Country, we see this kind of stuff, people trying to do this kind of stuff by themselves all the time. And it is frustrating that for a simple phone call, I would have run up the mountain, all of these things. And what we're really talking about here is, what will the public policy go towards the future? Will we look backwards and actually frustrate what the Mutter Supreme Court wanted to do, was to open up the holographic will? Or are we going to go into some necessary restrictive magic language requirement?
You agree that this is an unusual way to address that first issue in Mutter or Mutter? They did seem to go through and by attaching the document to the opinion, it seems like that was kind of necessary to their decision that this one doesn't qualify, and therefore we need to reach the second issue. So it seems kind of implicit. It's why they got to the second issue. It's a little different than what we usually see with dicta, where it's usually we're going to rule this way. We need not address. Although I guess that's just the nature of the term dictum, is something that's not necessary to the opinion. Sorry to ramble again.
Yeah, I agree that the dicta is something that is totally unnecessary to the opinion, and if you cut that language out, it would not diminish, alter, or affect or negative, if that's a right way to say that, it wouldn't reverse what the Mutter holding was and what it went to and what it reached towards. It was an opening and an affirmation of what a holographic will was. That was the question, that was the record, that was what was presented. And so all the discussion of witnesses is surplusage. It's
Although, as Ms. Aguirre is saying, if it got there only after having kind of given the back of its hand to the witness issue without deciding this issue. It wouldn't have had to get to the holographic issue otherwise.
I am arguing the position that the Supreme Court goofed up. It made a mistake in trying to find and go to, and this court can distinguish our case from the Mutter courts entirely. And that's the position that we're taking here. One thing that I wanted specifically to comment, when you receive the piece of paper and it has the testator's signature and it has two witnesses there, and you have that piece of paper, without it being self-proven, that is, with a notary attesting to it, it cannot be admitted to probate without a formal hearing, and at that formal hearing there is testimony brought forward, and the testimony fleshes out who were those witnesses, what did they see, where were they, what did they observe, and all of those necessary components. And that is what we believe we established in our record. So the document itself is only partially there. We believe in our record we established everything necessary under 142402 for this to be admitted as a valid will. We're dropping the words "and testament" because of the double language, devise, bequeath, the old English courts of equity versus king's courts. So, again, we don't think that the overqualification issue should be used to negative what was there actually in the record. I am a lawyer. I witness the wills that we prepare because as the lawyer I'd be called as a witness anyhow if there was a will challenge. So I regularly serve as a witness. I choose not to serve as a notary. We have notaries separately for that. The concept of a title, and that was another interesting twist. With MVD titles, the question is, who is actually in front of me signing this document? The purpose of the notary is to give a validation that somebody actually verified this person's identity and authority. An MVD agent is not a notary, but they can identify that as well if you go to MVD. And that is the purpose. Now, in real estate deeds, there is a specific requirement that deeds be notarized. You may be familiar with banking with the medallion signature requirement for stock transfers. The banks have their own unique system. So adding that does not subtract from their purpose and their function. And my time has come to an end.
Thank you very much. Thank you both lawyers for your briefing and for your argument. We'll take the matter under advisement and we'll issue a decision in due course. Now, we adjourn.